All right. Thank you all for your patience. It's now 3:10 and we are about starting our program. All right. My name is Dr. Dent Brefua Jem Frempong, and I will be your moderator for today's session. So, a word of prayer. Our Lord and Master Jesus, we thank you for this afternoon. We thank you for the gift of life. We thank you for everyone here. Lord, we commit our speaker into your hands. We pray that he is able to deliver and do justice to this topic for us so that it meets the needs of the participants here. In Jesus' name have we prayed with thanksgiving. Amen.
Amen.
So today we have with us Surveyor Dr. Pius Basua Asumedu, who will be doing the presentation. Dr. Pius Basua is the Regional Lands Officer for Greater Accra at the Lands Commission, bringing over 2 years, decades of extensive experience in land administration, land governance, policy, evaluation and estate surveying, and public sector management. With over 20 years of experience, he has distinguished himself in the industry. Dr. Asumedu has developed strong expertise in land management systems, regulatory frameworks, property evaluation, and institutional leadership within the public sector. His work reflects a deep commitment to strengthening land government structures and enhancing service delivery. He holds a Bachelor of Science degree in Lands Economy, a Master of Science in Land Governance and Policy, a Master of Applied Business Research, a Master of Public Sector Management, and a Doctor of Business of Administration. Dr. Asumedu is a member of the Ghana Institution of Surveyors and a proud alumnus of Mfantsipim School. Dr. Pius, please, you are welcome to today's session.
Thank you, Dr. Brefu, and all listeners.
All right. So please.
Okay. Good afternoon to everyone. And may I know if the screen is visible?
Yes.
Okay. So we start. Yes. Please, Doc, do you see it moving?
Yes, please, it's moving.
Okay, then I'll start. Okay, thank you very much. So today, we'll be discussing a topic, land acquisition and registration in Ghana. And we know the various issues that we face on a daily basis in our quest to acquire land in various parts of Ghana. So the presentation outline will be like this. We'll go through the legal framework for land administration in the whole of the country. Then we'll talk about some types of land and the land holding structures in Ghana, some challenges we face in our quest to acquire land, then due diligence prior to the acquisition of land, then the various processes of land documentation and registration. Then there is often some gray areas, and people don't usually understand the differences between ground rent, building permit, and property rate. We often misconstrue one to mean the other. So we'll decipher that difficulty as well. Then we'll talk about the Land Act and its implications to land administration in Ghana. So the mandate of the Lands Commission. People often confuse what the Lands Commission does and what it cannot do. So basically, the 1992 Constitution prescribes 5 functions of the Lands Commission. This has also been broken down into specific functions in the Lands Commission Act 2008, Act 767. But basically, the generic functions are 5. 1, we manage public lands and any other land vested in the President of the Republic of Ghana. We also advise government and also deal with traditional authorities on policy framework for development of any part of the country. We also formulate and submit to government recommendations on national policy that relates to land use and capability. Here, we have a symbiotic function with the Land Use and Spatial Planning Authority, that is the former Town and Country Planning Department. So this is where our functional linkage appears with the Land Use and Spatial Planning Authority. We also advise and assist in the execution of a comprehensive program for the registration of title to land throughout Ghana. Then we perform any other function that may be assigned to the Lands Commission by the Minister for Lands and Natural Resources. So basically, these are our functions. So the legislative framework, our mother law in the 1992 Constitution, Chapter 21, talks about lands and natural resources. So anything referring to the Lands Commission and land administration is captured in this chapter. Then our Lands Commission Act also set out our mandate. Then we have the Land Act of 2020, Act 1036. This is the mother law, the code, all laws that we apply in terms of land administration has been coalesced into one mother law as our Bible or our Quran. That is the Land Act. So ways by which we acquire land. People have acquired land through gifts. You can also get land through conquest. That is, our ancestors, they fought and got lands. Now, it doesn't happen in our time with this conquest. But lands that have already been conquered are owned by a group of people and they can alienate same. You can also acquire land by purchase or sale. Then by discovery, there's no land in Ghana that doesn't have an owner. So there is no bona vacantia land. Every land has an owner. So people have discovered land and they have owned it in that respect. Then the power of eminent domain by the states. The government has power to acquire by an executive instrument and by way of compulsory acquisition any land that it deems fit for public interest and for public purpose. Government can acquire any land that it wants. But per Article 20 of the 1992 Constitution, you have to pay compensation, which is fair, prompt, and adequate. So government can also acquire land by force. So the various types of land, we have public land, customary land. With the customary land, we have stool and skin lands. In southern Ghana, in the Middle Belt, the chiefs sit on stools. So the lands are called stool lands. And in northern Ghana, the 5 northern Ghana regions, the chiefs also sit on skins. So we call it skin lands in the north. We have family lands, clan lands, private lands, individual lands. Then public land, we have pure state lands. These are by acquisition instrument, by executive instrument, the government acquires land for public purpose and for public interest. Then we have vested lands. These lands are being held in trust for the people. So originally, this could be stool lands, but due to certain conflicts within the landowning group, the government vests these lands. So the legal ownership rests with the government, by the beneficial ownership. Revenues accruing from the management of such vested lands go to the beneficial owners. Then various types of transactions and interest. We have freehold interest. These ones, you hold the land forever ad infinitum. It doesn't expire. You hold it forever. We have leaseholds. These leases have a point of termination. It terminates, it expires at a point. So basically for residential purpose, we give 99 years, commercial 50 years. No matter the duration or the term or the period, a lease elapses. Then we have a sublease. This is a lesser interest created out of a lease. So if you have a lease of 99 years, you can carve out a sublease of 98, 75, 25, 50, 55 out of your head lease. Then we have assignment. An assignment, a holder of a lease or any other interest can grant an assignment. That means you are selling or you are handing over all your interest. So once you create an assignment out of your lease, all your rights have been extinguished. You are selling everything outright, whatever you hold. So if you hold 50 years and you are assigning the 50 years, you do not go back to the holder of the assignment, that is assigning, that you are going to take something back. You forfeit everything that you have. So that's the difference with the sublease and the assignment. For the sublease, when it expires, it can come back to you for renewal. But for an assignment, you are giving everything that you hold out to the assignee. The investing assent, usually, if you die with or without a will, your interest must devolve to the beneficiaries or your administrators of your estate, whoever you deem fit, so they can vest in themselves. So that is the vesting assent. Some challenges with land acquisition. When we come to the question time, I know more challenges will come, but just to tease out a few, we have multiple sale of land in the country, which is predominant in Accra and most of the big cities. There are feuding factions in families and stools, and this occurrence brings a lot of unrest to potential landowners. We often see impersonation. People hold themselves as landowners, which they are not. Unauthorized agents, these are the middlemen who play between the landowners and potential buyers. They create a lot of issues when it comes to land acquisition. Then some people do not provide full facts. They hide information, and we innocent buyers, we fall into their trap and buy and fight among ourselves. So these are some of the challenges that we face. Due diligence in acquiring land. It is incumbent upon every potential buyer to do this before you part with money. Before you buy land, or before you acquire an interest in land, or before you go for a lease or any kind of interest in land, you have to pay a site visit. Physically, you have to know the land that you are buying. Don't sit at the comfort of your home and be sending agents or people to go and negotiate on your behalf. You have to see whatever you are buying and see if whether the site plan they've given to you, if it has a plot number, see whether those plot numbers have been written on the boundary pillars on site. You also have to do your own local investigation to see. Someone said that usually when you go to an area you want to buy land, you have to, if you want to know the real owner, you have to find out from the drunks, those who drink in the area, the alcoholics. They will be able to tell you that, oh, this land belongs to this person and so forth. So if you see squatters on the land, you have to find out with whose permission are they on the land. And they can mention, then you will see. So you have to take note of all the names that they will mention. So when you meet the real owner, then you can confirm as to whether or not that is the name that you've been hearing. With your due diligence, you also have to find out whether there is any development on the land. If you see anything, a foundation or security post or fence wall, you have to probe further. It's a red flag because nobody will do this and just go away like that. If it's the one selling the land to you or the one leasing the land to you, is the same person who constructed those structures, so be it. But these are all flags that you have to look at. Then the local plan. Before anybody makes grants in land, the area should be schemed. So yeah, there should be a local plan where various lands are being zoned for various purposes. So if an area is zoned for an open space, you shouldn't go and buy. If the person shows you the local plan or the layout or the planning scheme and you see a place designated as church or a mosque or filling station, you shouldn't proceed to get that land for residential purpose. We have various uses that befits your intended use. So you have to look at that. Boundary pillars, as I mentioned, the plot numbers, if they are there, they write them on the pillars. Whether short pillars or long pillars, you will see the plot numbers there. If you see RD, it means it's a road. So don't buy. One day, your building will be broken down. In the due diligence process, you have to examine the one granting the land to you, whether that person currently, per the Land Act, if you're a landowner, whether a chief or a family head or so ever, you have to declare your proprietary boundary before you can make grants. So this declaration may come in a form of a statutory declaration where you declare your boundaries, that this area belongs to your family or yours too, and you must recite how you came by the land. And this process is published for as notice to the whole world. So you give your history. If it's by conquest, by way that you got the land, you declare, then you can make grants afterwards. If you had the land through court judgment, it must also be registered. Then if you have a lease, fine, you register, you have an assignment, fine, then you can grant sub-interest out of that. Is the one offering the land to you a joint owner with others? Usually, two people may own the lands. So it could be husband and wife, and one may play smart to sell to you. It could be siblings. It could be a limited liability company with different directors and shareholders. So you have to insist on establishing contact with whoever's name that appear on the deed or the indenture or the title. You have to check the signature, whether it tallies with their valid national ID cards. So these are some of the due diligence that you have to do by yourself before. If someone is offering you a land and the ID card he presents to you, you see his date of birth. If he was born maybe in the year 2000, so it means he's more or less 26 years by now. And if the land certificate or the registered deed or the indenture he shows to you maybe was registered in 2010 when he was just 10 years, it should raise a red flag. He was a minor by then and he didn't have capacity to have entered into a contractual agreement. If the father or the mother or an elderly person held the land in trust for him until he turned 18, it will be stated in the document he's holding that he was a minor. So all this, it's incumbent upon you to do these checks. But the main due diligence that we often say or pursue is the search, official search at the Lands Commission. And all that you need is the site plan or the cadastral plan. So here we advise that go to the land, get a qualified surveyor to pick the four corners of the land and generate a site plan for you, a cadastral plan, and use that to conduct a search. If you solely rely on the site plan that the landlord gives to you, it could be suicidal. Reason for saying this is that with experience, some dubious landlords may own two properties bearing the same name, their names. So he may offer you his certificate on land A or his site plan covering land A. Meanwhile, he'll be offering you land C where he doesn't have any title on it. When you come and conduct a search with the site plan he has given to you or the title certificate or the deed registered, it will show his name and you go ahead to pay. Meanwhile, he will be giving you the wrong land. But if you pick the land by yourself or by your own surveyor, you will realize the discrepancy. So this is an advice. Never rely on any Lands Commission staff that he has done unofficial search for you. Please. Now, with searches, we do online searches. So you can sit at the comfort of your home and apply. So in the area, as I told you about the drunks, the alcoholics, you find out from them who owns this land and they'll give you a lot of information. Squatters around may also give you information. So do your own neighborhood search and also find out more. Then litigation search, you can also find out from the court whether this area, whether there is any litigation, whether there is any suit or a judgment in that area. And the court may provide you with such information. On the due diligence, again, you deal with middlemen at your own peril. No matter how diligent the middleman may seem, still insist on establishing contact with the actual owner. Also, be mindful of such statements like, oh, you have to hurry up and build. See, that's all these people, oh, they are building. We are now doing the document for them. Someone may tell you, oh, we are in court, but they will deliver judgment very soon. We will win. Or we have a white paper with government. Very soon, government will write to us who own the land. So this is a hot cake land. Honorable so-and-so has even bought one. Please be careful. Hot cake lands are very dangerous. You may lose your money to these scammers. So, in obtaining your land document prior to registration, what we need is the cadastral plan. As by law, LI 1444-1444 requires that any registrable instrument must come with a cadastral plan. So our usual site plan, this is the nature and form that it comes. Being cadastral means it should be certified by a licensed surveyor and approved by the director of survey or his duly assigned representative. So this is how the cadastral plan looks like. In Accra and some regions, Oforidua, and some specific regions, you see this bar code in the reverse of the plan. It is for internal consumption, that there are some security features that we read with barcode readers for our own internal facilitation. So if you go to some regions and they prepare a cadastral plan for you and you don't see this barcode at the reverse, it does not invalidate a cadastral plan. It is also a cadastral plan. So we prepare a cadastral plan. That is first. And there are certain prerequisites that your surveyor will demand from you, such as the name that you want it to appear on the plan. And this, you should be specific because that's the same name that will be used in the typing of the indenture for you or the deed for you. So be consistent, avoid initials. Your full name, you give it. If you want it to be in joint names, husband and wife, you give the names. Usually we try to avoid Mr. and Mrs. Give your names as they appear, full names. Because if you say Mr. Brefo and Mrs. Brefo, without stating your first names, Mr. Brefo can get married to another woman, and the woman will also be called Mr. Brefo. So that is how it goes. Obtaining your land document once more. So this is the nature and form of a typical indenture. An indenture can be a lease, it can be an assignment, it can be a freehold, it can be whatever, sublease, mortgage. That is the nature and form of the deed. So the date comes, the parties, and all the reciters as appear, the plot size, the description, the consideration, the period or the term, all appear here. Then, as I mentioned, the name on the cadastral plan should be the same as appears on the face of the indenture. Then, types of registration in Ghana. We have dual registration in Ghana. Accra, the whole of Greater Accra region and Greater Kumasi, that is 2 square mile radius from Edum, we practice land title registration. So at the end of the day, you get your land title certificate if the land is situated in the Greater Accra region and Greater Kumasi. The other 14 plus regions, what we practice there is called deed registration. That one, we record the transaction between the parties. So at the end of the day, the same indenture that you submit for registration, we record the interest and we will return that same indenture to you. We will keep copies, like 2 copies. The standard is that you submit quadruplicate of the indenture, 4 sets. After registration, we'll return 2 to you. So when we return, you will see some stamps, about 4 different stamps on the document stating the plotting numbers, the deed registration numbers, and other vital information on the land. That is also a form of registration. It does not invalidate the registration. That is by policy, by law, and by an acceptable system adopted by Ghana's registration system, that Greater Accra and Greater Kumasi practice land title registration. And as we move on, I'll show you how a land title certificate appears. With time, as a matter of policy, title registration will be replicated in all the other regions, but they will be phased. For now, I think discussions are ongoing to introduce title registration in Western region, Central region, Eastern, Bono region, and I think Northern region. Discussions are far advanced. Requirement for registration at the Lands Commission. So as I mentioned, you need your cadastral plans, and you submit 4 sets of the indenture. And the indenture, the cadastral plan should be inserted in them, and the document should be duly signed by both parties with their witnesses. So these are pre-registration requirements. We need a copy of your valid national ID to confirm your name and other attributes in the document. Then a copy of the grantor's ID. In all other subsequent transactions, in assignments, subleases, these are all security checks that we do so that people do not forge your signature or don't use your identity to transfer your property that you are not aware of. Then any other document that we may require. So we have an online portal that if you want to submit your application, you can log on to. For now, for searches, we do online searches in Accra, and now it's been introduced in the Eastern region. Other regions will also have a field of online searches very, very soon. When you are submitting your application, we generate a bill for you and you pay. We have an on-site bank with our client service access units where you make payments. So that human interface that used to be is no longer the case. In application for searches, you can also pay on the Ghana.gov platform. For stamp duty, you can also make payment on the Ghana.gov platform. With time, all our services will be paid on that same platform. So that's the typical nature and form of a land title certificate. So when you submit your indenture or your deed or whatever instrument that you are presenting, at the end of the day, in Greater Accra region and Greater Kumasi, you will come up with this certificate with all the recitals in them. So you submit an indenture, then you go home with this, but a photocopy of the indenture will be inserted in the land title certificate. But you go home with a bound and with this seal and hologram and other security features on the certificate. So Greater Accra region, Greater Kumasi is what you go home with. Then in the other 14 plus areas, this is also what you go home with. The deed, the registered deed. That is how it appears. So various stamps will be on it, duly registered. So if you are in the central region and you don't have a land title certificate, it doesn't mean your land has not been registered. That is what pertains in the central region. So it is duly registered. Then ground rent. After registration, you are required to pay ground rent. Usually, we don't read the indenture, the agreement. The lessor reserves a rent for the lessee to pay. And this is on annual basis that you have to pay. And failure to pay this has consequences. So please read and know how much you have to pay. If it's a stool land or family land, you pay the ground rent at the office of the administrator of stool land, OASL. And if it is a state land or vested land, you pay the rent reserved at the premises of the Lands Commission. So that is what it is. So ground rent, this is different from property rate that we pay to the assemblies. After you have your registered deed, then you have to proceed with your designs, your how you want to build. So you submit your building drawing, your drawings to the assembly, and they will give you a slip, a development application letter to come to Lands Commission for us to confirm whether indeed your document has been registered. Then, after favorable planning clearance and favorable information from us that you have good title or you have a registered deed, then you will be granted your building permit to go in peace to develop your land. Then after development, you pay property rate to government, and property rates are levied by the assemblies. And you only pay property rate when your property or your building is from the window level. You get to the window level and above. So if you don't have a window, you don't pay property rate. We call it intoquiator. So, and this property rate is paid by the landlord. So if you rent a house anywhere and the landlord wants you to pay the property rate, don't pay. It's paid by the landlord, the property rate. Whoever owns the building pays the property rate. And usually it's revised every 5 years by these assemblies. So that is on property rates. Then let me just mention some specific sections in the Land Act. This is the law governing land administration in Ghana now. All the laws have been codified into this Land Act. And there are some offenses and implications. Section 12, subsection 1, talks about land guardism. So now, if you involve yourself in land guardism, whether you contract a land guard to obstruct a legitimate owner of a land, or you do it by yourself, you'll be held liable, and there's a summary conviction of between 5 to 15 years. So either the one who contracted the land guard or the land guard himself, both of you can go inside. You can be jailed. So depending on the judge, he can give you the minimum sentence or the maximum sentence. Section 236 also talks about unlawful sale of public land. People sell government land without recourse to the state. It's only the Lands Commission that has the power to grant public lands. So if somebody sells public land to you, you need to be careful. The one who did that sale will be arrested and jailed for a term of between 7 to 15 years. Then usually when there is dispute on land, when you even rush to court, the judges may resort to ADR, or they may plead with the parties to try ADR. If it doesn't work, then you come to the adversarial system. Then section 47, which is quite debatable, talks about restrictions on transfer of land by spouse. So the spousal rights issue is mentioned here. So if you have a land and it bears your sole name as Dr. PJ, only Dr. PJ on the document. If you are married and you acquire the land during the pendency of the marriage, if you are transferring, the law requires that we need the prior written express consent of your wife. Although her name is not on the document, but you acquired the land during the pendency of the marriage. The reverse is also true. If a lady also acquires landed property and is duly registered in her name, if she wants to transfer to any third party, will require the consent of the husband. But the exceptions, lands that you acquired before the marriage is your own property. Your wife or your husband has no claim to that. And lands that was given, your land that was given to you by inheritance, that your father gave it to you, your mother gave it to you, the spouse doesn't have a share in it. So these are some of the offenses and implications of the Land Act. There are other issues within the mother law, but these are some of the issues bordering on land acquisition and registration. Thank you very much for the time. So, Dr. Brifo Ajinfrimpon, this is a little presentation I have for our people. Thank you.
No, no, thank you very much, Dr. Baswa. Thank you very much. What my brother say? Oh, you do all. I just shouted, "Wow, what a nice presentation!" I believe myself and my colleagues we've learned a lot from this. So, colleagues, please, if you have any question, you can kindly type it into the Q&A session, and it will be read out so that Dr. Baswa will answer it diligently for you. Dr. Baswa, please, there are some questions, if you don't mind. I want to read them out so that you can help.
That's fine.
Yes. Okay. So please, Dr. Boutros is asking if we are giving an allocation form, is it considered as a deed or an indenture? And Dr. Kwame Danso is also asking, chiefs give allocation notes. How safe are they? If you can take those two questions for me, please.
Okay, thank you very much, Dr. Boutros and his colleagues. So an allocation note from a chief is just an intention to lease that land to you. And that is evidence of an intention to acquire. So after the allocation note, there is a step further that whoever has the capacity to grant the land must give you a lease or an indenture. So the allocation note doesn't come with a cadastral plan. It tells you that I'm giving you this plot. And usually in the Ashanti region, some chiefs do not have capacity to execute leases. So when they give you the allocation note, as being they being the occupants of the land, they give you the allocation note, then you proceed to a superior, either the Omanhi or the Ashanti's Land Secretariat, or whoever has the capacity to grant a lease, execute a lease between the parties. So the allocation note is a first step from the occupant of the land that this land is being given to you. Then he will direct you as to who has the capacity to do the lease for you. If the same person granting the allocation note to you has the capacity to grant the lease, he will so do. So the allocation note is not a lease on its own. There's just a first step. Thank you.
Thank you. More questions coming in. And please, a colleague wants to know that he registered his land as a dual national, first as a non-Ghanaian. What does he have to do to extend his lease to 99 years as a Ghanaian? And also, someone is asking if the property rate, is it being paid annually? And what is also the cost of processing cadastral for a plot of land in Ghana, please?
Okay. So I'll start with the dual nationality. So when he registered his land as a non-Ghanaian, I think there was a restriction. They gave him 50 years instead of 99. So that was a contract, a private contract between the lessor and the lessee. So now that he has become a Ghanaian, he can go back to the landlord. Then they will vary the term. So they can do a deed of variation to vary the term into what befits his current status. So all hope is not lost. He can go back to his grantor. Then they will do a variation to reflect the new term that he wants. So it's between the two parties, the landlord and the tenant, the lessor and the lessee. He should go back and explain his condition. Then it can be varied now that he has become a Ghanaian. Then the cost of processing a cadastral plan. Our fees and charges have been displayed in Accra. When you walk around our building, the fees are displayed. It's also captured across all our regions. And when you go to our website too, the fees are there specifically. But if somebody has charged you an informal fee, that one is not legitimate. So the fees are displayed on our website as well, which are not anything serious. They are being governed by the Fees and Charges Miscellaneous Amendment Act of 2022. So our fees are cleanly displayed. Then the property rate is paid annually. It's paid annually like the ground rent. But usually the assemblies don't come and pursue. So we will be there 5 years, they come, then they bring a bulk amount. So there is a lapse on the part of the assembly. It's also supposed to be paid annually, the property rate.
Doctor, I also want to ask if you could please go over the distinction between a sublease and a government
Assignment.
and
Okay.
an assignment.
Assignment. Okay, so Dr. Yosin, so for the sublease, usually the landlord will have a lease. A lease. So let's say if he has a lease of 50 years, he can grant you a sublease less than 50 years. So it can be 49 years of sublease, a subset of the lease. So sublease. Or he can grant you 20 years out of the 50 and reserve or retain the 30. So when your 20 years expires, then you go back to him for him to renew your 20 years. So he can also renew for another term of 20 years. Which you get 40, then he will still hold on to the 10. So that is sub-lease, is created out of the lease. Then an assignment can also be created out of the lease. But in this case, his 50 years that he holds or his 40 years that he holds, whatever he has, he's transferring everything to you outright. That you don't need to go back to him anymore. It has ended. So whatever he has, he's transferring everything to you. But with a sublease, he holds something. When your own expires, you go back to him. But for the assignment, whatever he has, he's transferring to you.
Thank you very much, Doc. And also, please, what actions can be taken against someone encroaching on a legally registered land? And also, what happens after the 99 years leasehold?
Okay. So the first one, the legal action, somebody encroaching on your land. If it is a state land that you've duly registered, the state doesn't involve itself in double grants. So if it's a state land, you can just remove the encroachment. And the Land Act permits that. But if it is a school land or family land, because the state doesn't have control, you need to see the law enforcement agencies. You have to see the police and report. And the police will demand the parties their registered documents. So if the other party is not able to tender what he has, then the police will advise accordingly for him to ward off the land. If it still persists, then you can proceed to court to get a demolition order to demolish whatever he has done on the land. So these are some of the remedies that are available once you register your land and anybody encroaches. Then what happens to the land after the 99-year lease. So it depends on the terms, conditions, and covenants stipulated in your lease agreement. Usually, we don't read in the lease agreement in the indenture. So if the term is certain, there are no revision clauses or renewal clauses. So there are some they state for a term of 50 years, for a term of 99 years. Certain. That one, when it ends, you've lost whatever you have on it. But if there is a renewal clause that so they state this lease so for 99 years, subject to renewal for a further term of, let's say, 45 years upon expiry of this term. So if there is a renewal clause, that means after it expires, you have an option to renew for a further term. But the law is forward-looking. So the Land Act is trying to protect citizens of Ghana that going forward, there are options. Lands Commission is making proposals for automatic renewals, but there should be a proviso that you should have been a good tenant. You should have lived without nuisance to your landlord. You should have been a good tenant. So all hope is not lost. There are options for renewal. Okay.
All right. Thank you, sir. And please, what's the difference between leasehold and conveyance? And another question is, how long should it take a landowner to develop his or her property?
Okay. So the first one, lease and conveyance. Okay, so I'll start with the conveyance. Conveyance is just an English word, but it also has a legal effect. When we say conveyance, it means transfer of an interest. You are conveying something. So that is the term. But in land law, conveyance usually refers to a freehold, a land that you hold forever ad infinitum without any termination point. That is conveyance forever. And in Ghana, there are some areas like the Tesano areas, part of Mile 7 and other areas, the Equapim areas, some hold freeholds. And the law, the Land Act, now bars freehold, creation of freeholds. But if you already have a registered freehold, you can transfer same. But if you have not registered a freehold and it's a fresh freehold that you want to register, the law doesn't permit that. Then the leasehold has a termination point. A lease ends. A period has a termination point. And there are two distinguishing factors of a lease. That one, the lessee should have quiet enjoyment and must have exclusive possession of the lease for the period within which that arrangement has been made until it expires. So the difference between a conveyance and a lease, the conveyance doesn't have an end term, it's forever. And the lease has a terminable term. So that is the difference. Then how long should it take a lessee to develop? It also depends on the development clause in the lease. Some development clause will tell you within 3 years, you should have developed the land. Some they tell you within the first year, you should have started developing. And by the 3rd year or the 5th year, you should have completed the construction of the building in a particular state. So it depends on what is stated. But if there are no development clause in the lease agreement, then fine, you are free. You can choose to develop 20 years, 50 years. But usually there are development clauses and it's about 3 to 5 years. They are there.
All right.
Thank you.
Dr. Nsafwa Yabua wants to thank you for your wonderful presentation, but has a situation and wants to ask this question. She's asking, in a situation where the plan has the name of Mr. and Mrs., as you said, can it be changed, making other documentation once the name is used, it has to be maintained throughout? And can the municipal, and someone was asking, can the municipal assembly grant building permits without land title from the Lands Commission?
Okay. So let me start from the the last to the first. So the assemblies, there should be no instance where building permits are granted where those lands have not been registered. And on the statutory planning committee, the fiscal planning, the special planning committees, Lands Commission is duly represented on the committee that approves those building permits. If by one reason or the other, they want to grant a temporary permit in times of emergencies, fine. But it shouldn't be the norm, and it is not allowed by law for permits, development permits to be granted where the lands have not been registered. So it's a misnomer if it happens. But we know they do happen in some instances. But that should not happen. Every person holding a building permit should have registered the land before that permit is granted. Then the first one, if you have already used Mr. and Mrs. without the full names, we just pray that Mr. doesn't get married to another lady to use your Mrs. So you can you can when you agree with your husband to transfer it into the names of the children, you can assign it to the children so that you free yourself of any thoughts. Alternatively, you can also convince him so that he will transfer into your name, your full name, or you and the children. Or you can agree to also maybe vary, but you can transfer to your children to be safe. So next time, you use your full names. But fine, you can. There's there's always a way out, but you just have to spend other money transferring to your name. You can also transfer to your both names using the full. So you assign from the existing names to the new names. Is that you pay for the registration. That's all that, but it's not suicidal. It can always be remedied.
And how long does it take for the Lands Commission to register a land? Can the process be monitored by the owner like is done in the case of passport application?
Okay. And so this we is a lapse for now, but we are working on it. For searches, it can be tracked as done in the case of passport applications. But for registration, we are not yet there. We are running a semi-automated system. It can only be tracked internally. We've not expanded that privilege to applicants to assess or track their applications when it comes to registration. But very soon we'll get there. On the duration, we've given the average turnaround times. A study was done in 2024, and averagely title registration, we're working around 3 months for first registration. But that's 90 days. But for first registration, it can be faster. It can be 30 days. We are working towards achieving title registration, full registration, whether first registration or not, to 30 days. That is the way forward. That's where we want to get to. Yes, that's where we want to get to. But for now, I must admit there are some lapses. But aside Accra, the other regions, they're able to do the 30 days in terms of deed registration is doable. So when we look at the averages, there will be slippages that may drag into 6 months and beyond. But if there are no queries and it's a smooth application, then we may even get it faster. So there may be extreme cases. There may be some that may move faster, but the averages are what we are working towards so that it doesn't bring about any favoritism. So we want to introduce a first in, first out policy. And we are really working on that as the FIFO policy. Thank you.
Doc, there's this question that is bugging me. I want to ask.
Okay.
It's the same as Dr. Constance Opoku is asking. Where is the safest place to purchase a land?
Doc, if
Yes,
you see, from where I sit, I'm even afraid. I don't even know the safest place to get land. And we are working towards getting land banks so that we publish on our website and we can direct potential purchasers to go there, which will be safer. Now, you cannot trust. It's a matter of trust. You may trust a chief, you may make recommendations, and it may go bad. There are other genuine areas where there are no litigation you can recommend. But tomorrow, then another feuding faction comes out of the family or there's two, then litigation erupts. Previously, state lands or public lands were the safest and they are well planned. But now I think they are scarce to get. So with time, this is a lot of work that Lands Commission has to do to get safe areas by way of land banks so that we can make them available. This means our collaboration with the traditional authorities needs to be expedited so that we can make Ghanaians happy and release some burden from this land acquisition processes. So we'll get there, but for now, I cannot tell you go here and buy. Thank you very much, Doc.
All right. So in the demise of the Queen Mother who sold a land to a person, and in securing the land, there is another chief standing in the way and claims the document issued by the Queen Mother is not legit. How should the owner go about this? And let me add another question to you. Dr. Caesar is asking that he has a lease from State Housing Company. It has expired. He went to pay property rates and was told that the lease has expired and they can't take the money. He's asking how safe he is.
Okay, Dr. Caesar, I'll start from yours and go back. So with your state housing company list, once it has expired, you have to go back to state housing for renewal of same. So since it has expired, they don't have any contractual arrangement with you. You take rent because rent is reserved in the lease agreement based on the contract that you have with them. Once it expires, you don't have any contract with them to pay rent. So apply for renewal and it will be done for you at a fee from the same state housing. Once you have the property, just renew so that you don't have any problem with them. Because they can use your non-payment of rent as a basis for re-entry to re-enter your property and grant it to another person. So please negotiate with them and the renewal will be done for you and you bring it to Lands Commission for registration. Okay. Because even state housing, they have done their renewal from Lands Commission. We are the ultimate grantors. We grant their head lease and their lease is expired and they've come to renew. And we charge them a fee. So you to go to them, let them take something from you, then they renew for you while you enjoy your property. Then the first one, the Queen Mother. Once the Queen Mother had capacity at the time and could alienate lands, whether she was a regent or the ultimate person to make grants. You see, a stool is an entity or an institution that has successors. So the new chief is just a successor in title. He has come to succeed someone. So unless otherwise, the Queen Mother did not have capacity to have dealt with the land. At the time, if the Queen Mother was the regent or she had capacity upon the demise of the previous chief, then nothing can be done. Then the lease is valid and legitimate once it's been executed. So if it's investigated and the Queen Mother had capacity at the time, then the new chief is just trying to extort money from the lessee. But if the Queen Mother didn't have capacity and there was a chief at the time or a regent at the time, then it is voidable. The arrangement can be vitiated. So these are the conditions. So you should find out whether she had capacity. Then that one you can take the chief on. Usually that's what they do. Some do. When they come and they see the lands are finished, then they try to raise all kinds of loopholes to get money. So investigate well if the Queen Mother had a capacity to do that, then he can't do anything to you. Thank you.
Doc,
Yes,
the
sir.
questions are plenty, so please,
Okay.
as in, get
We
a
are
bottle
there.
of water
Okay.
by your side
No,
because our colleagues
no problem.
are more interested. So let me allow you a 2 minutes breather whilst we allow our IPP. Dr. Serbo, add your voice to this, then whilst our speaker takes a 2 minute break.
Oh, Dr. Brefo, thank you very much, and good evening to every one of us on the call. I think it's been very, very educative. I have really enjoyed the lecture. There were things I took for granted, but I realized that there are things I need to go and do myself. And it is quite inciting to know that even as we live in our spaces, it's possible that our children may lose where we are because, of course, the leases may have expired by the time we die off. And I am quite intrigued with the Mr. and Mrs. thing. I think it's a very, very good education for all of us. You can have so many Mrs. Rebels, and yet maybe the initial one would have been with one particular Mrs. Rebel. So I think all of us will have to take a cue from it. So that if we have to buy anything and we need to register, let's register it in our individual names. And I would say that it's better we do so with our maiden names and not the one that we acquired through marriage, so that those inconveniences may not arise as we move on. I've really enjoyed the lecture, and I believe that most of us have also been educated. And so we'll continue to monitor and then also see how the questions come and then the answers that will come. We are taking notes. It's quite insightful. Thank you for organizing this, the organizers, and I must say that you've done a good job. So that is what I got to say for the meantime, for now. Thank you so much for allowing me to say something. Thank you, Dr. Ruff. It's over.
Thank you so much for adding your voice. All right. So, Dr. Baswa, please, can we continue?
Okay. So I have another question from Alex Pequado. Says if you have registered a land and the Metropolitan Municipal and this Assembly does not want to give you a permit, what can you do? So in this instance, their refusal to grant permits may be premised on some factors. One, maybe the land that you've registered, it has a different use, as I earlier said. Maybe the one who made a grant, the chief or the busuapeni, maybe that land is reserved for maybe industrial purpose or for civic and culture, for a church or a mosque, or for a market or open space. And it has been registered for you without recourse to planning clearance from the assembly. In course of registration, if the land doesn't have a plot number or the area is not schemed or there is no local plan or a layout in that area, we request for planning comments from the assemblies for them to tell us whether or not the land is zoned for that particular purpose, whether residential, commercial, industrial, or whatever use. Maybe the Lands Commission neglected that part and did not seek planning comment and went ahead to register. So if it comes like that, they may not grant you permit unless rezoning is done to be in consonance with your intended use. Otherwise, if all righteousness were fulfilled, all these requirements were fulfilled prior to registration, then they do not have any right to refuse your permit. And the Land Use and Spatial Planning Act, there are sections there that brings remedy to any applicant who applies for permit and he's denied on illegitimate basis. You can proceed to build. There's even a provision that if you apply and you don't hear from them for the next 3 months, you can go ahead and build. So there are ways to go about it. They have to give you a reason for their inability to grant you that permit, and it should be in writing. Then you can also respond accordingly. So once you've registered, you have a good basis to challenge them. So that is one. Then I see another question. It says, if you bought a land with a deed in the owner's name, how do you get your name on the deed? So the deed already bears the owner's name, so he has to do a transfer. So it can be an assignment or a sublease. So a cadastral plan to be prepared in your name, the new owner's name. Then a transfer document, an assignment or a sublease will be prepared. Then both parties will execute with their witnesses. Then he will attach, if he's transferring the whole thing to you, take his original document, deed that he has. Then you can submit a new one for registration. Then another question, can one submit a request for registration of a land in the Volta region to Lands Commission Accra? No, please. We've decentralized and registration is done on regional basis. It's not centralized. So if the land falls within Volta region, you have to go to our whole office to register. If the land falls within Kaswa, you have to go to our Cape Coast office. Going forward, we'll be establishing district offices that will bring convenience to our clients. Another question, what is the process for transfer of land titles? Let's say your grandfather left you a land and you want to change the name to yours. So if your grandfather is still alive, then you have to transfer in similar manner as I explained earlier. But if he's dead, then you have to get proof. Either if he died intestate, that means you have to get letters of administration. But if he died with a will, then you have to attach a copy of that will with probate and stating that that property was given to you. Then we can do the vesting assent and register accordingly. Using OSI plans, no, OSI plans are not accepted anywhere in our offices. For the cadastral, if you have a cadastral plan, fine, you can submit. But I told you Accra, the acceptable format is the barcoded site plan, just in Accra and some specific regions. So that is for our own requirements here. Then another question. Okay, if the chief has not signed, no, it's not valid. The indenture must be signed by both parties with witnesses. Okay, about the permit, how do you trace? I wasn't given any receipt. So do follow-ups. It will be done for you. If we're not given the receipt, you go to the fiscal planner, the head of the fiscal planning department, and you'll be sorted out at the assembly. Then, what are the rules that apply in acquiring family lands? What does one have to do to register such family lands, whether residential or farmland? So the same thing, the abusuapani or the family head will execute a deed for you or do an indenture for you. But you need to get a site plan first, as a cadastral plan, then the indenture will be typed. He will sign with his principal members as witnesses. Then you also sign with a witness. Then you can bring it for registration in respect of family lands. Then what is the average timeline to have a purchase land fully registered? So I mentioned in the other regions, because they practice deed registration, the timelines are quite faster. But in Greater Accra and Greater Kumasi, because of the title registration process, please, the newspaper publication in terms of first registration is mandatory. And this at least takes 14 working days. So 14 working days it means 2 weeks is already gone. It's almost 3 weeks. Yes, almost 3 weeks. So you should also be very fair to the timelines, but we can do better. There are some bureaucracies that we can limit, and either they are matter of law or policy. We are revising our processes. We will get there. But now we are looking at an ultimate 30-day turnaround time across our various offices, whether deed or title, but we are not there yet. But the landlord, what will happen when the lease period is over? So it depends on the renewal clauses that was inserted in the lease. If it's term certain that is not be renewed, then so be it. But usually there are renewal clauses for a further term. Must all lands be registered with the Lands Commission before they can be sold? Yes, please. You cannot give what you don't have. So you must register your land before you can transfer. What about sales of lands by chiefs that are not registered with the Lands Commission? As I said, the Land Act now requires and mandates all allodial owners to register their proprietary boundaries. So, as I mentioned, the statutory declaration, if you're a chief and you don't have any document at all, just do statutory declaration and tell us how you came by the land, and do cadastral plan covering your land and come and register before you can sell. So that is with it. Every chief should declare his boundary, and this limits conflicts. What about an indenture yet to be signed because the original chief passed and they are yet to select a new one, but building has already been built? So once it wasn't signed, a new one will be typed bearing the name of the successor in title. The new chief will sign. Then you go for your document. But usually they will demand signing fee or drink money. So you can approach it in that wise. But you need to pursue and get your document when you want to sign. Usually when one dies,
please. Hello, Doc. Please, you mentioned ADR in your presentation. Is that alternate dispute resolution? Hello?
Yes. Hello, Doc. Yeah, I mentioned
Yes,
ADR.
sir. Okay. Someone just prompted me and wanted to know the ADR. Okay, sir. All right. Let me also help you with the questions.
Yeah, so
If
with the ADR, so still, you see, into my phone's hospital, they didn't give us access. Well, they said it wasn't around, so they didn't give me access. But it's on, so you should make it on. Hello. Okay.
yes, sir.
So,
Okay.
so with the ADR, yeah, usually there are a lot of land cases at the courts, especially at the land courts, and they delay. They take time before education is done. So usually, land cases we advise that you resort to ADR, either arbitration or mediation or whatever means. Then it is resolved expeditiously. So land cases, you have to try ADR first. If it doesn't work, then you go full scale litigation. And usually man to man, when it could be boundary problem and it can be established by survey. So usually land cases, they resort to ADR before, if we are not able to make any headway, then you go full scale. Because maybe the land that you are fighting over, maybe the site plans may be different. Your land may be the adjoining plot, but you may be fighting on the same land. These issues could be technical. It could be resolved before going to waste your time in court. So even the judges recommend to try ADR before the full adversarial system.
Right. And I
If I
also
bought the
want
land
to add
before
this on behalf. The association has lands in Volta region and has made it mandatory for all the lands to be registered. But there has been delay with the registrations, with some about 2 years and counting. Is there anything that has to be done by our association to fast track these registrations? And it's not just in Volta region, other various GMA divisions have similar issues. Is there a way which, as in your office, can assist our association?
Yeah. So we are there to assist. So in such instances, let a rep of your association approach the regional lands officer in that specific region himself. Then whatever is the problem, it will be resolved. Maybe the one who submitted the document, uh, maybe there are issues with the application that they are not communicating. Our office is not communicating. So please approach the regional lands officer himself, and the application will be tracked, and whatever needs to be done be expedited, because 2 years is quite a time in the region. So please let your leadership or any representative approach the regional lands officer himself.
All right, sir.
Okay.
Okay. And if someone has said, if I bought a land before marriage but built on it later on during the marriage, and the unfortunate situation that is there's a divorce happens, how is the property being shared?
Okay, so the property, you bought it before marriage. The land, the structure that you have on it, anything affixed to land, per the definition of land, anything affixed to land is part of land. So if you bought the land before marriage, whatever is on it, the document covers it. So it will not be treated as property acquired during the pendency of the marriage, unless otherwise the husband can prove that he invested in the construction of the structure. Other than that, it is treated as property prior to the marriage. So I don't think any learned judge will say share the property. You acquired it before the marriage, and it's covered by a legal instrument as of a particular date before the marriage. So that is it. Unless the husband can prove that I gave you the money, or he can prove with receipts that I bought this for the construction. So these are all matters of law. But once the document bears a date before the marriage, he will have a weak stance to argue. Okay.
So Dr. Sebastian is
Let's
asking
move
from
on.
you, a person cannot apply for a land permit without without registration of land. Does that mean the process of land permit acquisition cannot start without the registration? Also, are there some consequences for not registering a farmland after acquisition of allocation of papers and site plan?
Okay, so Dr. Sebastian, your question is in two parts. So the first part, yes, you have to register your land before applying for permits. The two cannot be done concurrently. But if by any means you apply for the permit while registration is ongoing, they will wait for you to get the registered deed before the permit is granted. Unless otherwise, there is double assurance that the registration will go through. Then the assembly can risk and give you the permit awaiting the registration. But the norm is that they should be registered before permit is granted. Then the consequences, they are enormous. Please, whether farmland or building plots, please get your site plan and your indenture and register. Allocation papers are not enough. Let the indenture be executed, plans inserted, and bring it to Lands Commission for registration so that nobody comes to contest with you, because the same chief can grant another allocation paper to another person on the same land, and you will not be safe. So try get your indenture, your deed, come and register.
Right. Dr. Paul Frimpong, the divisional chair of Bono Ahafo region and the medical director of the Sunyani Regional Hospital, wants to thank you for your wonderful presentation. And also, please, is there an online link to search for? What is the
Yes,
online
please.
link for the online search? Yes.
Yeah, so
They want to know the website.
Okay, so it's online services .lc.gov.gh. Online services .lc.gov.gh. Online services.lc.gov.gh. That is our link, and we are posting it there. Then for
Dr.
complaints.
Regina Dakwa wants to ask. Okay. All right.
Okay. Dr. Regina Dako Asante. Average cost.
Yes, please.
I answered this. Yeah, we have it on our website. It's there, but we don't have a specific, because it depends on the nature of the instrument, the location. Land values are relative. When you are registering a land in cantonment, it's not the same as a land at Nkoko. So the land values relativity also comes, and the plot size. Also, there are indicators and parameters that we use, but they are not anything to be scared of. Our fees are regulated by Parliament, and we have fees and charges. And you can see them on our website. Is it possible to have multiple people with the same cadastral plans for a plot? Yes. A cadastral plan doesn't confer ownership. It's just a survey, a plan done for you. So 1,000 people can do a site plan or a cadastral plan on the same land. for different purposes. One may acquire this cadastral plan for a search or any other reason. So 1,000 people can do cadastral plan on the same land. It doesn't confer ownership. And please, can you reiterate briefly the requirement for an indenture? That is Dr. Justice Brown. So basically, you get your site plan. Then the landlord, he's supposed to give you the indenture. Then when you get it, you read it well, whether all the recitals you agree with them before you sign. And he will also execute with his, if he says two, his principal elders, and if it's a family, his principal members of the family. Lease land. Okay, Dr. Itel says, I want to know about how lease land of estate development is going to affect our future property land ownership. Oh, so if an estate lease land of estate development is going to affect our future property land ownership. So once it will depend on the term in it. So if you've been given 99 years, no matter what you develop on it, is renewable. So you shouldn't be scared. And once you get a land and you don't have immediate plan to develop, you can do a fence or a security post on it or get something on the land, and that will be development. And keep on paying your ground rent, and that'll be a good basis to have it be secured. Then there's another question. Without a barcode, type of the old type of plan without a barcode. If it was registered at the time and you have your title, no, it's still valid. Because at the time, that was the acceptable plan there. Okay, so the process, you get a surveyor, a licensed surveyor, to get a barcode plan for you. It can be done. So every licensed surveyor knows how it is done. He applies with your name, then you pay the requisite fees, and it is done. You will come to the site to pick the point, and it's done for you. So if you want to update your plan, it's also doable. Dr. Felix Amuaku, in respect of land ownership and transfer to another party, why would it be an offense if the land so acquired was acquired solely by one party in the marriage without any evidence suggesting contribution of the other spouse, and he or she transfers it to another party in light of recent Supreme Court ruling? You know, these are contentious yes, cases and scenarios. It's a novelty now that these emerging issues are coming. So we'll be testing the laws. There's been Supreme Court decisions and rulings on this, as you've espoused, but other people may also challenge certain things. And you know, the law doesn't take retrospective effect, so they will check the dates as and when those properties were acquired and all those laws. And this Land Act came into being on 23rd December 2020. So all transactions that were done before 23rd December 2020 will not go by this new order. But those that came after 23rd December 2020 will be affected by this new order. There have been instances where land searches are done at the Lands Commission and have been told they are good, but later it turns out to be government land. What do you do when it happens like this, especially when payments have been done up to the registration level? We've had some of these challenges. I've observed two searches. One was done and they said it's not government land. Later, another one was done. They said it's government land, which has created a lot of hardship on the applicant because the applicant relied solely on the information we provided. We used to run a pure manual system, and this usually happened in areas where there are boundary issues. So, as in a human environment, there could be genuine mistakes, and some too could be systemic. So, I wouldn't deny that this doesn't happen. It happens. But when it happens, either you fall victim to it, we can always assist. We can regularize your interest for you. Then we'll consider what you've paid to the chiefs, and we can offset that in our premium that we will give. So there are ways to assist. Okay. Dr. Benedicta Watima Amuafo. Okay. Since I have a site plan, I have a site mapping of land. I want to apply for okay. Oh, okay. Let's go. Yeah, let's go through. Okay, so Dr. Watima, I want to apply for land title. How long is that supposed to take? Also, how do I know how long I have on the land since I purchased it as a sublease? So with the site mapping, the plan that you have, conduct a search and let us see the name of the rightful owner, and we can advise accordingly. The name that pops up is the person you should deal with for him to give you an indenture for you to register and get your land title. And you can also see the term that is left on the land to give you full disclosure about everything about the land. Dr. Baba, please, how do I go about the process of getting a titled certificate for a portion of property given to me as an inheritance out of two plots? Okay, the documents I have now, an indenture and a site plan allocating my portion of the property. Do I have to go back to the chiefs who originally sold the land to my father, or proceed straight to the lands commission? Okay, so if your father owned those two plots and he duly registered, then if he's still alive, fine. If he's not alive, then a vesting assent will have to be done so that you vest the property in your name. So as I said during the presentation, if you died intestate, then you need a letter of administration from the court as the beneficiary of his estate. Then if he died with a will, then you need to apply for a probate that he gave you that land, then we do a vesting assent and register for you accordingly. You don't need to go back to any chief. If your father did not register the land, then you need to go back to the chief. So conduct a search with the site plan and let's see what name that will come up. Then Dr. Jennifer, why does one need a tax clearance form to retrieve his or her land document? Also, aside the tax clearance forms, what other document can be used to collect my document at Lands Commission? Okay, so for deed registration, it is mandatory for you to present a tax clearance certificate evidencing your position as a taxpayer. And Ghana Revenue Authority gives this tax clearance. Then you present it for the registrar of lands to get a tax clearance and register, do the deed registration for you. And this usually happens in the non-title registration districts or the regions. So this tax clearance issue is quite frustrating, but you need to get it out to the deed. If I have an allocation form plus a cadastral registered in Lands Commission and a building permit plus proof of annual school rent payment. Can I use this to register in the Lands Commission? You need an indenture, a deed from the one who gave you the land. We cannot register with allocation form alone. We need an indenture. What does a Ghanaian, Dr. Eunice Abdullahi, what does a Ghanaian do if they are leased for 50 years, not knowing it is 99 years? You can always go back to the grantor or your lessor to renegotiate or to correct. If it's seen as an anomaly, you can correct because it's assumed to be an agreement between the two parties. So once you sign, if it's 50 years and you execute, it means you've taken it, you agree to the 50. But if later you realize that wasn't the agreement, but it was 99, you can always go back and vary a term and represent to Lands Commission for us to register the 99-year interest. Dr. Richard Insia, for land litigation issues, how do one go about it to avoid losing their land despite proper checks? And suppose if after the litigation or land dispute, the buyer isn't interested in the land anymore, the question is, how do you get your full money after payment to the landowners? Because it's very difficult to get your money back and on time. In this case, what can be done? This is very practical and it happens on a daily basis. So the landowners will be reluctant to refund your monies to you. The best option will be for them to give you another land, which may also have issues. So you may need to put pressure on such a person to get your money back. So a lot of pressure works on them, and it's quite unfortunate.
Look, it's rather unfortunate when the money goes, as in the palace, it never returns. It's rather unfortunate.
Very, very unfortunate. Dr. William Bosu, what approach would you advise if informal fees are compulsorily demanded before your documents are registered, or if the processing is unduly delayed when you do not pay any informal fees demanded? Please, every employee has a boss. So if somebody demands an informal fee from you, you can always report the person to his or her boss, his superior. And our doors are very open. Please approach us, and we want to clean the system as much as possible. So any informal fee, if per your own volition you want to give willingly, no problem, but somebody demanding from you before a service is provided, please let us know. And the district assembly grant ownership of land to an individual or group who do not have title to a land but present a nice development plan to the assembly. The law is that it should be registered before a permit is granted. But once the assembly, they want development in their area, somebody can deceive them with a nice development plan and they may grant title. As I said, the special planning committee, Lands Commission rep is on the committee. So we should be able to advise that no, it should be registered before. But for one or two reasons, they may not listen to our advice, or people may acquiesce to whatever it is once they think development is coming to their area. So that's also another issue. Please, from your vast experience, that's my senior, Dr. Kobnati Butechi. Is my senior from school. Please, from your vast experience in land issues, what do you think causes the extremely prolonged litigation with regards to land ownership conflicts? Land is a factor of production, the basic factor of production. And land it's also a spirit, and land is property, is real property. So people ascribe a lot of importance to land. And in determination, in determining who is the rightful owner, it takes a lot of care and caution. That is why a lot of documentation will have to be provided to prove that this person is the rightful owner. So we must also understand the courts when land issues go there. Now we have automated land courts, and I think they expedite judgments on this land ownership conflicts as compared to previous years. But they are very careful when it comes to land. Somebody may falsify an ancient land document to show that his ancestors were the owners of the land. And another person may come with a colonial judgment. You have to be very, very careful. So land issues, they travel a lot, and it may take years for it to be resolved. And a lot of political twist and yes, and a lot of tensions when it comes to land issues.
Doc.
Okay, Dr. Erica. Yes, Doc.
Yeah. Like the questions, honestly, there are many, but I think we
Then we'll
can't
get another
exhaust
day.
all of them today.
Oh,
Would it be
okay.
Yes. Would it be possible maybe to get a contact where we can channel some of the questions to?
Yes, exactly. So, okay, so we'll put our complaints and advisory center. We'll put the
Right.
number on
Okay.
it. Yes, in the chat. 050 55 78 100. So 050 55 78 100. So we've also put it in the chat. 0505578 You are welcome, Doc.
Okay. So on behalf of the Ghana Medical Association and the CPD committee being chaired by Dr. Med Kwekua PJ, we want to say a very big thank you to Surveyor Dr. Pius Baswa for your presentation, and that too. We also want to thank the Lands Commission for honoring our invitation. Boss, we are very grateful to you and your entire team.
Thank you very much, all
right, sir.
ardent participants. So we'll meet again as and when you want us to have another session. Thank you very much.
You're welcome, sir. All right. So on this note, I would invite Dr. Charles Luanga Bayel to say the closing prayer for us. Dr. Charles.
All right. So thank you very much. Shall we be in the mood of prayer? God, our Heavenly Father, we thank you for this day. Thank you for granting us the session we just had. We pray that whatever it is we've learned concerning lands, help us not to fall prey to people who might want to create problems for us. Pray that you help us to also continue to give of our best for the people of Ghana and for everyone as a whole. This is a minimum we ask through Christ our Lord. Amen.
Amen. Thank you very much. Also, we'll be putting up the schedule for next month on the various pages, the schedule for CPD programs for the upcoming months. Kindly make it a point to join the CPDs. The MDC points are free, and in the course of the year, we will be uploading the points onto the various portal. Thank you all for joining, and have a good evening. Bye-bye.